the judge is given the authority and can order a young person at any stage of the proceedings to be referred to a child welfare authority for an assessment as to whether they're in need of child welfare services. But in that case, the concept is that the young person then will be dealt with in the child welfare system and not in the criminal justice system. Court has the power to make an order for a psychiatric, psychological, or psychoeducational assessment, or perhaps all three. That can be done at any stage in the proceedings, must be on consent of the parties, or by order of the court on evidence of psychological or emotional disturbance or learning disability. Those assessments are confidential with very strict limitations as to access to the report. And that, of course, assures the privacy of the young person. This is, again, a unique provision in the Youth Criminal Justice Act. In the Adult Criminal Court, you can have referrals to psychiatric assessment for issues of fitness to stand trial, perhaps on issues of sentencing. But this is very particular. This can be at any stage prior to bail. If the court is considering, or if a justice of the peace is considering bail and has concerns about the mental, emotional, psychological health of the young person, they can make a referral for this assessment to determine what would be appropriate and what conditions might be appropriate in terms of a release. No statement made by the young person during such an assessment is admissible without the youth's consent, except in very specific occasions and appropriate. One being hearing on a fitness to stand trial. Well, obviously the assessment is core to that hearing. A review of sentence. If a young person is before the court and asking for a review of their sentence, and I'll speak to that, another unique provision of the legislation in a few minutes. Any statement by the young person in an assessment can be brought to the attention of the judge. On a Crown application for an adult sentence, and indeed I'll speak to that again in a few minutes, but if the Crown wishes a young person over the age of 14 to be sentenced as an adult, they must make an application before the court, and I'll discuss that procedure in a few minutes. Any hearing on capacity to form intent. Obviously, I guess the best example is intent to commit murder, for instance. Does the young person have that capacity? Well, of course, any statement made by the young person during the course of an assessment on that issue ought to be admissible to the court for its evaluation. And then finally, if the young person chooses to testify at trial, and there's been an assessment, those statements in the assessment can be available for the purposes of cross-examination of the young person, should they testify, to challenge their credibility. If a young person testifies at trial and is saying something different than they said in the assessment, it's only fair that that should be put to them and that their credibility ought to be tested on that issue. Psychoeducational assessments are something that really are unique to the Youth Criminal Justice Act, and they are remarkably important. I would think that in any case where the court at 311 Jarvis Street, any of my colleagues, when we were considering custody, we would order a psychological assessment if there were any indication that that was necessary. But we would very often, if not the vast majority of the time, order a psychoeducational assessment. I'm mindful again that we were in inner city court. Many of the young people had challenges of a number of nature, of several natures coming before the court. We would order the report to be, an assessment to be made, and we'd ask that it be made independent of a general psychological report. In the psychological report, often, usually, the ones that we've received, psychoeducational assessment was part of it. But a psychoeducational assessment is fundamental to the education of the young person should they have a disability. And in fact, if an assessment establishes that a young person has a disability, the school boards in Ontario, and I think it's general throughout the country, are mandated to put in supports to allow the young person to succeed in school. That's an extremely important provision. And I'll give you a case example. It's really remarkable. A young man appeared in front of me. He was involved. He was charged with fraud. He was 16 years old when he appeared in front of me. He was pleading guilty. He had a secondary role in the offense. The primary role was that of a taxi driver who was stealing either the card or the information from a credit card and then passing that to the young person, who then went to bank machines or other machines to extract money from the innocent victim's account. And a considerable amount of money was taken. Very little of that money ever ended up in the pocket of the young person. He had no previous involvement with the criminal justice system. He and his family had immigrated to the country when he was a child. He was conversant and totally fluent in English. But when he presented in front of me, the first thing I noted was that he was very reserved, shy. His shoulders were stooped. He was looking down. And I learned in a pre-sentence report, after he pleaded guilty, a pre-sentence report was ordered. I learned that although he was 16 and socially, if you like, was in grade 11 in high school, he in fact only had 2 grade 9 credits. So it struck me, as in many cases before our court, that there might very well be a learning disability, and that might be something that should be investigated. So I was satisfied that a psychological assessment wasn't really necessary for the young person, at least initially. I thought that the psychoeducational assessment would be very important, and indeed it was. When it came back, and it took about 6 or 8 weeks for that report to be prepared. It came back. The young person, by the way, was at liberty. He wasn't in detention. When it came back, we weren't surprised to find that, in fact, he did have a learning disability. He had problems processing information. And one can imagine it's a little difficult to absorb information and translate it then in exams or reports if you have a processing problem. He had a serious one. And that then, of course, was going to be directed to the school board to be accommodated within the school system. More importantly, it turned out that the young man was in the very highest 1% for mathematics. He was brilliant in mathematics. He had the academic capacity to do doctoral level mathematics. When he came back before the court, and this had been, he'd been advised of this, he came in, his shoulders were back, his head was up, he was smiling. He had affirmation for the fact that he had great value. So I adjourned the matter again for a couple of months, 3 months, I think. I wanted to make sure that the school board put accommodations in place to allow that the educational assessment would have value. And when it came back, what did we find? Well, we found that he's an A student to start with. So with the processing issue accommodated, he was achieving A grades in virtually everything. And he was tutoring other young people at the high school in mathematics. Truly a life-changing event for the young man, all accommodated by that very special provision in the youth criminal system. Really very important. Findings of guilt. Findings of guilt in the youth criminal system are not convictions. It does not allow for an adult record unless, as I indicated and alluded to before, and we'll speak again about, unless the Crown seeks an adult sentence. With compliance of any sentence imposed after a finding of guilt within the youth system, and after a certain period of time of passing from the time of that sentence, the record for that sentence is, if there's compliance, is erased. And it's as if the young person was never charged. They go into adult life, or if they turn into an adult while still that record pertains, they enter adult life without any record whatsoever. There are restrictions on the access to youth records, very, very strongly worded in the legislation. The length of retention of those records is limited to ensure the privacy of young offenders, but also of victims and witnesses. Their names cannot be revealed, or identifying material for victims and witnesses cannot be revealed as well. Very important provision. The time, as I indicated, the time of retention of those records is based on the specific finding or sentence of the court, and they're set out in the legislation.